First, before he goes to sleep.
He's fine.
Yeah, he's been. That's mine. That's mine. David.
Good afternoon. We're going to try. We're getting started about almost an hour late. Can y'all hear me okay? How about now? Hear me all right? Okay, I hate using these things. I'm going to. We had a lot prepared for you, but we're going to run through this pretty quick so that me in particular, because I want you to be able to hear these guys. They're really something special. You know, the way I look at it is, I'm going to just put this down. Can y'all hear me okay? Yeah. Okay, the way I look at it is you start your preparation for voir dire the same way as you do with a lot of other stuff. You have to ask yourself, what is it that I need during this this part of the trial? Of course, what you need from the jurors is information, right? Because you got decisions to make. We don't get to decide who we're going to keep on the jury. The only decision we get to make is who's got to go. And to make good decisions, you need good information. That's what we need from the jury. A lot of people like to use voir dire to introduce their case themes. I do too, but only because I want to see how the potential jurors react to what we're going to be doing. So what we mainly need from the jurors at that time is information. And because of that, it's important that jurors be as candid with us as they can possibly be. All your jurors and everybody that walks in that courtroom have got core beliefs, things that they've been taught since they were this big, preconceived notions, biases. Every single person walking the earth has them. That's the kind of stuff we got to get to. And the ironic thing is, it's the hardest part to get to. There's a quote in the materials from David Brooks, and it's kind of cryptic, but what it boils down to is this is why we need this information. Jurors have preconceived notions and beliefs that are the core of their entire belief system, and they're going to interpret the facts that they hear and the things that they see by looking through those beliefs. In other words, they're going to interpret them in such a way that it makes sense with what they already think and believe. So that's why we've got to get to those, and it's hard. There are a lot of barriers to getting to this candor, and we've got to get those barriers down. And some of the barriers are, one of the things what I like to call the juror's ordeal. And it starts when they get that jury summons in the mail. And you can just about imagine what they say. Now I got to take off work, I got to have people pick up the kids. Not something they want to do. Then they got to go down to the courthouse. Well, most of them never even been there, and they got to find it, and it's hard to find. And then they got to find a place to park. And then they got to walk, and by now they're late. And they get in there, and some guy with a badge and a gun says, "Go in that room and sit down and be quiet." And they go in there, they don't know another soul in there, they can't find a place to sit, and they sit and wait. And then the judge comes in and reads them the riot act about how important jury service is. And then somebody calls their name out in front of all these people, and they get herded down to another room where they sit and wait some more. And then the judge comes in and reads them another riot act, and then the clerk calls their names out in front of everybody again. And they go sit in a box up there in front of everybody. And they listen to the judge for a little while, and then they have a prosecutor who has no idea how to do voir dire sit there and preach at them and try and sell them something. And after all of this, then it's our turn. They've been through this entire ordeal, most of a day, and it's 4 o'clock in the afternoon, and a total stranger walks up to them and says, "Hi. Can I ask you some personal questions? Is that okay?" "So, do you pee in the shower?" Why should they talk to us? I mean, after all this. So this is something that we've got to overcome, and there are ways to do it we'll be talking about in just a minute. Another barrier is fear of public speaking. The research that's been done in this area shows that speaking in public, speaking out in public, is the #1 fear of the average American. Snakes is #2. Maybe it's #3. I guess death's #2. But you get the idea. You're here in this room with these total strangers, and you desperately need them to talk to you, and they'd rather die. So what do? Status dissimilarity is another thing, and I'll talk more about the flip side of that. Distractions that they've got going on. Distrust for the legal system. Distrust for lawyers. So we have to overcome these barriers, and there's a lot of really good ways to do it. One is, I talked about status dissimilarity. That's when they perceive that you and they are different in status. Okay? You're in the courtroom. This is where you work. You're an officer of the court. You're a highly educated trial lawyer. This is where you work and play. They're just an average citizen. How many of you see people go to trial wearing their $1,500 suits? Everything you, yeah, I don't have one, but I see other people. Everything you do says something to people. Everything the way you dress, the way you act, the words you use, they're watching you the minute you walk in the door. So what we need to do is show them that we're like them. Okay, the way we dress, the way we talk. Lose the big words. And I always tell this story to illustrate. There was an old hometown lawyer when I was a baby lawyer growing up, country lawyer named Coy McKenzie. And when I was an intern, I was watching him do a drug trial, and his defense was it was a setup because the narcs wanted to sleep with his client. So he has his client on the witness stand, and it comes time to talk about the nasty business, and he says to her, "Now, ma'am, during the course of your interaction with these two individuals, was there a time when certain suggestions were made upon your person?" She says, "I don't know what you're asking." "Well, isn't it true that at some point certain insinuations were made with which you did not entirely accede?" She says, "Coy, I'm sorry, I don't know what you're asking." He had a legal pad in his hand, he threw it down on the table and says, "Doggone it, did you try and get in your pants or not?" Okay, been a lot better to ask the question that way in the first place. Who talks like this? Prosecutors and cops. You don't indicate something, you show it or you tell it. It's not a vehicle, it's a car or a truck. This didn't happen subsequent to the other thing, it happened afterwards. Lose the big words. When we talk like lawyers, every word that leaves our mouth tells these people, I'm different than you. I'm smarter than you, at least I think I am. This is my place. Body language. What are you saying with your body language? People worry a lot about what do I do with my hands. Josh Carton, who is a guy that's just a genius, he works with us in the Trial Lawyers College, likes to do a thing about hands in your pockets. Well, what about you, man? We've all seen people do this. Ladies and gentlemen, we have nothing to hide. Body language is important. Probably the most important thing to me is creating the right atmosphere. Now, those of you who have judges do the initial voir dire, you might ask them to do this for you. The problem we have, and there's a lot of research on this, and it's been published in journals. I've got the articles. If you want to email me, I'll try and get them to you. You don't tell anybody where you got them. I don't want to get sued for copyright violation. But part of the way our brains work is when we're having an unfamiliar experience, we're searching our memories for similar experiences that we've had so we can achieve a little comfort level and go, ah, it's that type of deal. So what kinds of experiences do we usually have where we have to answer questions out loud? Anybody?
School.
Tests, right?
Parents.
Your parents interrogating you, where you've been. Job interviews. So the problem that we have is that when jurors are being questioned, if they're not being asked the right questions the right way, and if the atmosphere is not right, research indicates that their first gut feeling, their first reaction is going to be to say, not what's the true answer, but what's the correct answer. If you go in for a job interview with a very conservative firm, and they're sitting there interviewing you, they all got their GOP pins on. You may not believe that George W. Bush was a great human being, but if you want that job, you better say so, because that's the correct answer. So that's not what we want. We don't want to, prosecutors always ask the questions, do you understand beyond a reasonable doubt doesn't mean beyond all doubt? You understand that? You understand that, don't you? Yes. Okay. You get no information that way because I'm telling her the answer that I want, and that's the answer I'm going to get. Now, she may not believe it, but that's the answer I'm going to get. So jurors have to be constantly reminded. They have to be indoctrinated from the very beginning and constantly reminded that there are no wrong answers to the questions that we ask. Only true answers. They have to be constantly empowered and reinforced. You people are the most important folks in this courtroom. You've got a right to have the beliefs the beliefs and the feelings and the thoughts that you have and the notions that you have. Your beliefs are just as good as anybody else's. You got every right to have them, and no one has a right to criticize you. All we want to do is ask you about it. We want you to be proud of them and tell us about it. It's not a test or a job interview. Another question I like to ask, you hear people tell jurors, what we're trying to figure out here is if you're right for this case. The right question is this case right for you? And I'm going to get into that a little more later. Another important way to overcome those barriers is to be yourself. Be yourself all the time. The most successful trial lawyers you see are the same in the courtroom as they are sitting down there on the bar stool talking about the ball game, minus the profanity. Now, the problem with this is, Mark Twain once said, you know, be yourself is the worst advice you can give to some people. So, rule number one, be yourself. So there's a subsection to rule number one. Rule number 1A, which is be yourself unless you're an asshole. In which case you probably need to do some personal work. Credibility is key all the time. Again, research has been done, and one of the things we stress at the Trial Lawyers College, and we'll go into the story that Jerry tells about how he discovered this as a young man, but research indicates that if you will share something about yourself, you will disclose something about yourself, your jurors are much, much more likely to follow suit and disclose the things about themselves because you're going out on a limb. How many of you are, I've been doing this 31 years. I'm still terrified when I try a case. How many of you feel the same way? Tell them. I mean, you're this, I know what you mean. I'm terrified until we actually, it's like a ball game. You kick it off, then you're fine. But you know, you get to thinking about the responsibility you have. And the fact that this poor soul is in terrible trouble and they trust you and they're relying on you. That huge responsibility. And one of the things, you know, that some of us like to do is say, you know, folks, I'm really feeling that pressure right now. This is a pretty big deal. You know, I wonder if any of you maybe feel the same way. Okay, so now I've modeled the behavior I want and I've given them something and I'm more likely to get something back. The right questions in the right way. Prosecutors like to say, do you understand beyond a reasonable doubt doesn't mean beyond all doubt? Yes. Okay. Does it make sense to you that we don't have to prove that, you know, blah, blah, blah? Yes, no. These are the answers they're getting. What kind of information do you get? Ask open-ended questions. Most of y'all know this. Questions that start with how, what, where, when. Get narrative answers because this is what tells you how they think and their decision-making processes. It's different when you're going for a challenge for cause. Okay, and we all know this again. The challenges for cause, you got to lead them, you got to help them get there because most people want to do the right thing. Okay, you've had these experiences, sir, and they were pretty traumatic for you. Kind of sounds like maybe this wouldn't be the right case for you. Okay, we're going for cause. We're doing what Robert Hirschhorn calls putting them in the cause coffin, leading questions. Now, one thing that you can do to get creative, to really get down past those barriers is ask topical questions. Not long ago, I had a trial for a client who was Hispanic. Just so happened there was a state question on the ballot to make English our official language in the state of Oklahoma. Now, what do you think that's about? It's about pulling up at the stoplight and here's the guy in the next car with the Latino rap. Or going to the store and the guy can't speak English. Okay, so we ask questions about, you know, how do you feel about that? Making it our official language, because that kind of tells us a little bit about how people feel about foreigners. Big deal in the news a while back. Are we going to take the terrorism suspects and try them in a military court or a civilian court? Now, why do you think someone would not want them tried in a civilian court? Anybody?
They might be acquitted.
Too easy to get off, isn't it? Doesn't that tell you a little something about their attitudes about the court system? I mean, I could ask them, how do you feel about the court system? Oh, it's good, nice people, blah, 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 blah. You don't want that. So be creative, and topical questions will help sometimes. Scaled questions, how many of you know what that is?
Spectrum.
Scale questions. It's a really good tool because you ask somebody a question, do you believe this, yes or no? Black or white. Most people are in the gray area. And all the scale question is a neutral question or a proposition question. How strongly do you agree or disagree with the following statement? person who doesn't testify when they're charged with a serious crime is probably hiding something. Number 1, strongly agree. 2, agree. 3, somewhat agree. 4, somewhat disagree. 5, disagree. 6, strongly disagree. You get a number from them. They can give you some nuance. And if you use your scale questions, put the least favorable answers on the bottom of the scale at 1 or 2. And the most favorable answer is at 6. If you ask 5 or 6, and I had a visual I was going to show you, but we don't have time for that. 5 or 6 different scale questions, and you need visuals for it too, because people get confused. Then you add up their scores. You get a number. It's not the end-all, be-all, and it shouldn't overcome your intuition and the other things that you use in making your decisions, but it's a good tool to use. Most important thing, David Ball said, who's a great civil trial consultant on damages, number 1 rule is shut up and listen. Doesn't do us any good to ask the right answers or ask the right questions, get good answers if we're not listening. We want them to pay attention to us. So we got to do what I call turn off the TV. How many of you have teenagers at home? How many of you have any kids at home? Okay, more of you. You come home and they're sitting there watching TV and you say, "Hi, son," and he goes, "Hi, Dad. How was your day?" "Fine." Do you want to talk to this person anymore? Isn't it better if they put the remote down and turn to you and say, "I'm doing fine, Dad. How are you?" So eye contact, pay attention, listen carefully. What do you do with the unfavorable juror? The tendency we have is to argue with them. Okay? They think the criminal justice system is too soft on criminals. Well, yeah, but don't you think that? Okay, what have we done when we do that? We've shut them down. We told them in the beginning that we wanted them to be completely honest, and here they're being honest with us, and when we're giving them a negative reinforcement. Number 1, that shuts them down. Number 2, it shuts down the other people that you need to hear from that feel the same way. Number 3, you've made a liar out of yourself, and your credibility's out the window. The better response is to tell them how much you appreciate them being honest with you and coming forward with that information that you really need. Remember, you just told them their opinions are just as good as anybody else, as good as your own. It encourages people to speak up. It enhances your credibility. I'm going to kind of move on here because I want you to be able to listen to some of the others. How many of you have heard the expression "innocent until proven guilty"? Is that the law? In our jurisdiction, our jury instructions say the defendant is presumed innocent, and that presumption continues unless the state proves beyond a reasonable doubt that they're guilty. Is there a difference between until and unless? Talk with your jurors about that. You will not believe what you hear. It's amazing. Biases and prejudices. Bias and prejudice are negative words. People don't like to admit that they are biased because they think of bigots and other despicable people. So we have to kind of change the metaphor there, and we have to say, biases and prejudices. Think of a better metaphor. I don't like green beans. I'm biased against them. Am I a bad person? No. So kind of change the metaphor there. I'm going to skip the part on objections because I'm sure none of y'all ever get objections when you're doing voir dire. I don't usually make objections when the prosecutors are doing their thing because, number 1, what they do is completely ineffective. They don't get the funny thing is prosecutors don't have to be any good at voir dire. How good do you have to be when the first 12 people in the box generally think you're right to start with? So most prosecutors don't know how to do voir dire, and they're not listening anyway, so it doesn't matter. It's not about that for them. So I generally don't object because it's not hurting me and it's not doing any good. And if I let them do it their way, I expect to be able to do it my way because our way is the right way. One thing that I didn't want to forget, I'm going to back up a little bit. Do you voir dire on beyond a reasonable doubt or not? A lot of cases are not beyond a reasonable doubt cases. There's a difference if someone comes and says, "You stole my wallet," and I say, "I did not steal your wallet. Let me tell you what happened." As opposed to, "You stole my wallet," and I say, "Well, you can't prove it." Okay, now I'm going to try a manslaughter case in a couple of weeks. That's a beyond a reasonable doubt case. They just can't prove it. But if you are going to voir dire on beyond a reasonable doubt, how do we ask them? I mean, what do you really want to know? The prosecutor says, "You understand beyond a reasonable doubt is not beyond all doubt." Well, you get a yes. How many of you ever heard anyone say no to that? It's crazy. Better still, and we're not allowed in our jurisdiction to define what beyond a reasonable doubt is. I can ask them what they think it is. And what I do is I use a scale, 0 to 10. 0 means absolutely not possible, didn't happen. 10, absolutely 100% positive. So you tell me on this scale of 0 to 10, where is it for you? And you can do things with that. Ask them where probably is. It's a little bit north of 5, probably. And you can compare and contrast. People will tell you what they think beyond a reasonable doubt is. And again, you got to listen. We tried a 6-count rape and lewd molestation case a couple of years ago. I had 2 people on that panel that said beyond a reasonable doubt, it's 10 out of 10. Prosecutor left them both on. She's not paying attention. She's busy making fun of what we're doing. You know who it was, don't you? Left them both on. She's not paying attention. So, and that's the thing. We worry about questions exposing good jurors to us. Don't worry about that. They're not listening. So, cause challenges, and this, and I'll get out of here and let you hear from the rest of these guys. Again, we want to use leading questions. I do. And it gets back to the question, are you the right juror for this case? The correct question is this case right for you? And this is the metaphor that I used. And of all the stuff I use in Voir dire, this is probably the only thing I didn't steal. So it's original with me, and you can use it if you want. But how many of you have gone in the last year or so, gone shopping for a pair of shoes? Did you try on any shoes that didn't fit? Sure you did. Well, does that mean there's anything wrong with your feet? No, it's the shoes are the wrong size. Did you buy them? No. So that's all we're talking about here. If this pair of shoes doesn't fit, don't buy them. If this case is not right for you, don't make the mistake and be here. Let's talk about it now. The other thing, and again, we're changing the metaphor. People are worried, if I can't be fair, there's something wrong with me. That's not true. It's a lie. The other thing, and I'll leave you with this. Everyone agrees that it's every American's duty to sit on juries. The thing of it is, it's our duty as good Americans sometimes not to sit on a jury. And all you're asking, is this one of those cases for you? Is this one of those cases where it's your duty not to sit as an American? Gets them every time. So guys, I appreciate the chance to talking to you. Wish I had more time. You're not going to believe what you hear next. Thanks.
He's a hard act to follow. He's been teaching Voir dire at Jerry Spence's school for a long, long time. I wish we had a chance today to do what JW and David were getting ready to do, but it's going to take too damn long. So having said that, I think I'll go to Jack Jr. He's the classic country lawyer. By the way, these 3 guys have probably between them tried 50+ death penalty cases. I tried 1 to remind myself never to do it again. Junior, come and talk to me.
I tried 11 on my last one. I can't do it again. Trying to death penalty case will gut you. It scares you. It scares me now, because I got this kid I got to defend in September, and he's 20 years old, and he's black, and his buddy capped 2 young kids out in the park one night for nothing. And he looks at me and said, "Well, I didn't pull the trigger, Mr. Gordon." And I said, "Son, it doesn't make any difference. You're there, you knew what was going on, and you're likely to get the needle just as well as this other guy." He didn't get it, and I can't help it. You know, if I were 6'2", it looked like Gregory Peck. Voir dire wouldn't be quite so hard, but I'm not. But I have some advantages, as do you, whenever you start your voir dire. And what's the advantage? The advantage is that the prosecutor has bored the jury to death. They are asleep, they're scratching their butts, they're turning in their chairs, they're nervous, they're just crazy. Now then, You gain instant credibility by standing up and being nice, and looking nice, and acting nice. I talk. Now, I do dress pretty nicely. I believe in it, because that's my courtroom. I've made it my courtroom from the time I walk in until the time I get up. The jury knows who I am. I mean, I come from a small town, and I have a hell of a reputation all over Oklahoma, but especially in my town. So it's no joke as to who I am. But still, get up and walk up to the center of the jury panel, and say, "Good morning. I want to visit with you, and I want you to visit with me just a little bit." And you heard this is voir dire. Sorry, voir dire. That's what we say in Oklahoma. And voir dire, and don't talk to the dumb juror in this one, but talk to the smart one. And Miss Smith, voir dire are the French derivatives from the Latin words that mean to speak and to hear. In other words, we're going to speak and we're going to listen with each other. Okay? Now then, Ms. Jones, there are no wrong answers in this proceeding. I want to know how you feel about this issue, about what we're going to talk about. Because maybe you're not the right person for this jury. And if so, nothing bad. They got 500 other cases coming right on up. Be nice. Be easy. Now then, I memorized the names of the jurors, okay? I believe it's critical. I believe it helps my credibility immensely, because I can say, "Mr. Smith, how do you feel about such and such?" And Mr. Smith gives me an answer. Whether I like it or not, it doesn't make any difference, because I'm going to walk right over here and I'm going to say, "Mr. Cal, you heard that answer. How do you feel about that?" And then I'm going to walk over here and I'm going to ask Mr. Jones the same question. What depends on what he said. But when I'm walking around, and I don't walk and talk, by the way, I walk, get set, and then visit with, never point. Now then, sir, Jesus, are you going to shoot him? And I've seen lawyers do that, and the juror jumps back and it's just terrible. Open-ended questions are so important, but you have to study your case, know what your issues are, have your theme for the defense ready so that you can question on those issues. It's nothing to do like the elected prosecutor in Tulsa County does. Can you be a fair person in this trial? Well, shit, everybody can be fair. And I don't care whether they're fair or not. I want somebody that's impartial. And fairness and impartiality are two different cats entirely. So talk about that with the jury a little bit. And then look at all the issues of your case. And issues not necessarily in the forefront of your case. I represented Stan Williamson in a murder case. I do a lot of murder cases. And he's a world champion cowboy, by the way, and accused of killing his ex-girlfriend's husband. And during the time of all this action, he and she slept together. She was married to this other guy, and he wasn't married. Well, in Oklahoma, that doesn't go over very well. Now then, that really had nothing to do with my case, but it had everything to do with the jurors that I needed on my jury. And so I asked this one lady, I said, the facts are going to be in this case that Stan Weiss had slept with so-and-so, and she was married to the guy that got killed. How do you feel about that? I mean, you know, she just, I take it that you didn't like that very well, and you don't like that. And it really goes against your religion, doesn't it? Yes. And your morality, yes. And somebody that would do that, it's hard to be fair and impartial whenever you know that that happened. And I'm telling you that it happened because the evidence will show up whenever this trial starts. Now then, do you believe that you can give Stan Williamson a fair trial, knowing full well that he slept with that lady right over there? And she was real honest. She said, no, I can't. I asked the judge to challenge for cause. He kicked her. 5 more that I got off the jury for cause on that issue alone. Didn't have anything to do with the case, but it's critical to who sits. You don't want her on there. She's going to get you. And if I didn't ask the question, it's going to come back to haunt me. In another case, I represented a fellow named Larry Schaefer, who was a big promoter and 49 years old, charged with 2 counts of rape, 2 counts of indecent exposure, which I kind of thought got subsumed by the rape. In other words, you have to get that thing out to do the deal, but I couldn't get that over to the judge or anybody else. And a couple of other counts. Well, the alleged victim was 16 years old. And we alleged that one of the rapes didn't happen, or sexual encounters didn't happen, and admitted to the other one in voir dire. I said, now, there is no question, ladies and gentlemen, that Larry Schaefer had sex with whatever her name was. And she's 16 years old. I think Judge Beasley would tell us that 16 years of age is the age of consent. Matter of fact, I think I've just asked you. And I asked him and he did it. Gave me a little free instruction that 16 years old is the age of consent. And so I started asking questions about what they thought about a 49-year-old man having sex with a 16-year-old girl. And I started knocking them off right and left. They just couldn't do it. And a fun trick. Late in the day, one lady was having a fight with herself. Because I'm talking about this deal, and she said, I try to put that behind me. I don't think it's really right, but I try to put that behind me. I try to be a good juror. And I said, well, I like trying, and I appreciate your answer. But what if you go ahead and tell me that you're not going to let it affect you, but you go back in the jury room and all of a sudden it gets all over you? That wouldn't be right, would it? No, it wouldn't. And so it was kind of late. And I said, well, why don't you go home and think about it? And then let's talk tomorrow. And then I went on and talked to 2 or 3 of the other jurors, and by that time it's 5 o'clock. It's time to have a drink of scotch, and you're up for the next day. So I came back the next day, and she was the first person I talked with. Mrs. Smith, did you think about what we talked about yesterday? She said, Mr. Gordon, I was up all night. I said, well, if it's any consolation, so was I. Now then, what do you think? She said, I can't do it. I can't be fair. I want the judge to take me off. Now then, you're gonna get answers like that from most of the people you talk with. Not all. I lost the best case I ever tried. The jury lied. They lied to me. It was a death penalty case, and planned to kill 5 people in 6 weeks. And, I mean, it was not pretty. And they all testified they didn't know anything about it, and that was bullshit, because they did. Came back an hour and a half guilty on an insanity case, and the judge looked at me and said, I don't know how that ever happened. I do. They lied. Anyway, that's the way I do it. Get personal. Get right down, right in front of them. Get to stand in front of them. Don't, and I never put my hands in my pockets at a courtroom. Ever. I talk with them. This doesn't know how to screw in anything or wrench something. These are for talking. Okay? So use your hands for talking. And thank you very much.
I'd buy a used car from you, buddy. J.W. Coyle, all of these guys, we've been together a long time. J.W. Coyle, Oklahoma City.
Well, I mean, I've got a hell of a couple of acts to follow, so I'll just put my hands in my pockets, and I'll tell you a good story. My wife, Julie, who's right here,
And I need your camera.
always says that after she shoots me, she's going to hire Jack Gordon Jr. So there is.
I quit it too.
And the guy that works with me on every single case I ever have is David Smith. I mean, these are special friends of mine, and they're lawyers that love people and love to help people in trouble. Let me, I've got some things to kind of follow up on some of the things my friends have said that I think are really important in jury selection. And I think that all of us that are good jury lawyers, or think we are, you know, if you don't think you're a good jury lawyer, you don't need to be doing a case in front of a jury. And it's not for everybody. But whenever you talk to them, you got to find out what it is you're afraid of in your case. And, you know, there's a lot of racial prejudice in Oklahoma. And that's a good example. And there's a lot of racial prejudice everywhere in the country. But if you represent someone, say, a black man in a trial, then you got to find out about that. And the way you do that is you share with the jury one of the things that David was talking about. You say, you know, I hate it. It's ugly, but I have prejudices. I'm prejudiced. And hell, so are they. All of us are, in a certain way. Because we are either uncomfortable or scared of people who are different than us. And so when you start talking about that, people want to be a champion of what's right. And they'll get to talking about it. And then it becomes a center of the trial to be extra fair to your guy, to whom they wouldn't have ever been fair to in the first place. So what you got to do is you got to find a way to share yours with them. And that's what makes them tell you the truth and talk to you about what's going on in the case. Because you just tell them what you're afraid of. If it's a confession case, I had a confession case that I was successful in. And I talked to the jury about, hell, I saw he confessed. and so what do you think? And I mean, I had one lady say, well, you know, the police might not have been fair to him. And then I looped her over, what do you think? And someone else. And then they all started talking about it. By the time it was over, the confession he made kind of went down the drain. But those are just some of the ideas. And one of the things we were going to do, and we'd like to do, you know, David Smith and I learned, Voir, really a way that I was doing it even before I met Jerry Spence, but we learned a lot of it from Jerry, and it was, he looks at what he's afraid of in the trial, say it's racial prejudice or a confession or whatever the thing is in the trial. And then he tries to find that feeling in himself, and then you talk to the jurors about it and see what they think. And it involves some other techniques and too, like psychodrama, which is very, very valuable. And I just won a case a few months ago because in an assault case, because we went through psychodrama. And for those of you, is everybody familiar with psychodrama? Anybody? How many of you are? Okay, for those of you who are not, it is a very powerful tool for lawyers. It's incredible, really. And all it is essentially a reenactment of what happened in a certain scenario. And if you go with someone trained to take someone back to that point, it really brings them back and they can make it very real. I mean, it's almost scary how real it can be. And what it did for me in that case is it made it so real that when my client I did action direct with her, where I took her through, she's the defendant, I took her through what happened in the assault and why she did what she did. And it was so real in front of the jury that there was, it was beyond belief. And this shit works. If you find out what you're afraid of in the trial, and you find it in yourself, and you talk to the jury about it, and be honest with the jury that that's why you're afraid, and just tell them. And when you come in there at first, and you feel like all of us do, so nervous, tell them. Just say, I'm nervous because of responsibility I have. And they'll say, someone else will say, I'm nervous. And you just have to share with them, and you have to kind of get down on the level. And I wanted to find out, those of you, if you have a trial in the next couple of months, would you raise your hand? A jury case? Everybody does. One of the things we were going to do was try to...
JW, you guys want to see this? Won't take long.
Yeah, do it. Do it.
These guys work together day in, day out on Voir, and hit it.
Can you tell me what the issues are in your case?
The one that I raised my hand about?
Yes,
It's basically, it's a guy, excuse me, charged with possessing a firearm that was,
Okay.
oh,
Come on.
okay.
I'm sorry. I'm John Coyle.
Michael Levinson.
And here's my wife's lawyer, Jack Gordon.
My wife's too, I'm not damn sure. Where should I go?
Just right here.
Okay.
Tell me a little bit about your case.
Okay, the one that's coming up soonest is a guy who's charged.
Can you all hear him okay?
Yeah, I'm kind of looking down.
Right there.
Oh, there's a
microphone with a long cord.
Here we
There
go.
it is.
Okay. Okay. So I have a client who is charged with possessing a firearm. And he was in an apartment. The firearm was shoved between the mattresses of a bed, and then out on the patio was a box that had some drugs and some money that they're basically trying to pin on him.
Okay.
So it's a possession of a firearm and drugs in my drugs.
And so what's your biggest fear in the case, other than, of course, the evidence? I mean,
Well,
the issue.
well, the biggest fear is that circumstantially, there's no one else that it could really be pinned on. There's no cop-out, so there's no confession. At the sort of deeper level, this is a relatively young black guy who, doesn't present himself outwardly all that great. Comes across as a little edgy and angry. I don't plan to put him on. I have, and although I can't say, I never make that decision until I absolutely have to. And my fear is just basically the presumption of guilt from the circumstances, the evidence, and then who he is as a person.
Okay, but the evidence is that he was just there.
The evidence is a little more complicated than that. He was in the room, he was in an apartment. There's a big commotion in an apartment building. 9/11 is called. They have evidence of possible activity in a variety of different apartments. They knock on the door to the apartment that he's in. There's evidence that somebody tries to scoot out the back. They kind of interrupt that, come back. The door is opened. He supposedly tells them that he's on probation. They search the apartment, and shoved between the mattresses of this bed is this firearm. And he's got priors for this, so he's looking at kind of time for having the gun. And then they go out in the back, and on the patio, they claim they heard this stuff get shoved out the window or thrown out and land right behind his apartment that he was in. Okay.
Let me borrow that for just a second.
Of course.
All right, we're going to need some audience participation here. What I would like to do is to have you folks on the first two rows be our jury panel. Okay? This is really important part of the process. We call this enrolling. What I need you to do is think of somebody you know really well that might get summoned for jury service. Okay? Someone who's not a lawyer. Someone you know well enough to know what their politics are, their religion, how they feel about the court system, how they feel about crime. Okay? Think about what they do for a living, whether they go to church, how they dress, how their body language. I want you to become that person. Okay? Put that hide on and become that person. And take just a minute. Think about who you are. Enroll. What are you wearing? How are you sitting in your chair? What kind of things are going on in your mind, places you'd rather be right now? Okay? And what we're going to do is we're going to do a little exercise, and we're going to get some feedback from you guys. Enroll as this person. You are now that person. Okay? Right, step on over here just a second. Now, tell us again what your number one fear, in 10 words or less, what's your number one fear about this case?
The lack of a coherent alternative explanation for the presence of the
Now give me that in English.
no one else to pin it on.
Very good.
Okay. Don't have any other story to tell.
No other story to tell.
Okay. Well, so we know what it is that you're worried about now. We need to find out why that bothers you. Okay. So what I want you to do is just kind of, as a person, not as a lawyer. Okay. We know the facts of your case. Just kind of think out loud for a little bit about and tell us how you feel about that and why that bothers you.
I feel afraid. I feel that I have a responsibility for this client. I feel that, and why it bothers me? Or it bothers me because there is kind of a presumption of guilt by circumstantial evidence of that kind. And I guess what really, honestly, now that I think about it more, what really bothers me, honestly, at a deep level, is looking like a schmuck trying to explain something that's going to be very hard to explain.
That's honest.
Well, I guess we all know how that feels.
Honestly, that's really what it is. I mean, I'm dancing around it, but deep down, I feel like how do I do this without coming across like a schmuck?
So what I want you to do is I want you to do a couple of minutes of voir dire with this panel, the way you usually do it.
Okay.
Your usual shtick. Okay? All right, step up here and go. Use this so they can hear you better.
Well, I mean, I have a whole bunch of introductory shtick.
We've done that already.
Okay, all right, so we've done all that stuff. So, Mr. Jones, you ever found yourself in a situation where maybe you were accused of something or suspected of something that you really didn't do, and were just having a hard time explaining to people how this came to be, even though you knew you didn't do it?
No.
You've never had such a explanation, a situation in your life.
No.
How would you feel? So I'm already doing what you guys were doing, but how would
do
you?
what you usually do, and
Yeah,
then we'll
yeah.
maybe do it a different way.
Well, I'd probably be stuck at that point. So
Okay.
then I'd probably find somebody else, and I'd ask the same question. So I'd say,
You're narrating now, just
okay,
do it.
Ms. Jones, have you ever had a situation where you were suspected of something or accused of something and you didn't do it, but it just felt like everybody was saying that you did? Can you tell us a little bit more about that? What kind of a situation was it, and how did you deal with it?
I have to pretend I'm someone that
You're not pretending, you are that person.
okay.
Lead the mic. Well, let me just ask you another question. If the people that seem to be, saying these things about you were people in authority, people in a sort of an official status, like, say, a police officer, did that make it harder for you? Did it make you feel like there was so little that you could do about it?
I'm sorry, can you repeat that?
Well,
Hang on here a second, let's check in with her. Hand me this mic, will you?
oh, sure.
Now, enroll as this juror, okay? Tell us how you're feeling about this exchange, what's going on right now.
I feel nervous.
You feel nervous? Okay, how do you feel about really telling him what he needs to know?
Uncomfortable.
You're uncomfortable? Okay. And let me ask this gentleman here, if you hand me back the mic. How did you feel about interacting with this guy?
I felt like he was asking yes or no questions, and unfortunately, I'm channeling my goody two-shoes wife, who's never been in that
You are
situation.
her.
I am her. So when he asked me the yes or no question, I can think back and honestly say, no, I haven't had that situation.
Okay. Well, you said no, and he moved on. How did that make you feel?
It made me wonder if maybe there is something in my past that I should have thought of it, and maybe there was a different way to frame the question.
Maybe there's something wrong with you.
Maybe I wasn't accused of it, but maybe other people thought it and just never accused me.
Let's check in with the rest of you. If we were doing the full Monty right now, we'd do what's called sociometry, which we'd get you guys on your feet and put him in the corner and ask you to stand closer or farther away from him, depending on how connected you feel to this guy right now. Okay, we're not gonna do that. Give us some feedback about you. Enroll as jurors. What's going on? How do you feel about this guy? How do you feel about what's going on? Yes.
My subjective, or the person that I'm channeling, my subjective feeling during the exchange was that it wasn't an authentic exchange. I kind of felt like he was playing a role the way I'm supposed to be playing a role, and I didn't feel really connected with him. And part of that was a product of a short yes or no question and then just moving on quickly.
So if he comes to you and asks you some questions, how are you going to feel? Like opening up to him? You're going to feel guarded?
No, I felt closed off to him. I felt like I was not prepared to be open.
Thank you.
Yeah, I didn't feel closed
I
off
don't
with,
think you
with
need
the role that I was playing. I didn't feel closed off, but I was trying to answer the question in my head that was being
You got to
posed.
stay in role, okay? Stay in role as the
Oh, so
person. Stay in role.
Other person.
Yeah, so I am this other person.
Right.
So I'm just describing.
Good, thank you.
Yeah, I'm just describing
Sorry, I
how
misunderstood.
that other person would feel. So answering that question in my head, I'm trying to be somewhere else. I'm thinking about being someplace else. I think this is really stupid.
You're not engaged.
Well, I'm thinking about the questions he's asking because I want to answer them and get it over with.
Okay.
And I'm listening to the way other people are answering it, and I'm thinking about a situation. But then when it became to law enforcement officer, I thought to myself, I'll just tell the police officer what happened, and that would be it, and be over.
Okay.
You know?
How are you feeling about this guy? Are you going to feel like you're going to open up to him? You're going to kind of be guarded?
I'm gonna
Maybe
just-
something in
I'm
between.
going to just answer the question as quickly as
Okay.
I can, and then hopefully he'll move on like the way he did.
Thanks.
Okay.
Thank you. Anybody else with any feedback? Okay. What's that? Pardon me? Yes.
In my mind, voir dire isn't a question and answer, it's a conversation.
Sure.
It's a chat. And there was kind of unintelligible questioning with an attempt, there was no chatting, there was no communication. Talk to each other, talk about something.
Sure.
And if you raise your voice at the end, it'll sound like it was a question.
Well, in my defense, I didn't get my 5 minutes of
True.
having
And,
talk.
you know, that is a good point, because we're kind of short on time here.
Right.
Step up here now. Now, you shared with us something that really bothers you about this case.
Right.
Okay? And, of course, you haven't had a chance to practice this or put a lot of thought into it, so it's not going to be polished. And that's not what we're after right now anyway, okay? I want you to go back to that place when we were talking about what really bothers you about this case and how you felt about it. Let that sink in for just a minute. Now, why don't we
While he's pondering, if I may,
Sure.
we're looking at calling it at about quarter after to give him some time to work. And a quick reminder, 5 o'clock, opening the reception tonight.
Thank you. Okay. Why don't you just share with these folks what you shared with us a minute ago?
I'm sorry, just to clarify, so, okay, as if
Here's
they haven't already heard.
Here's what we're doing. Spence says that he developed this theory when he was 10 years old out in the garage with his buddy and 2 little neighbor girls. And he says to them, we hear that you're a little different down there. Why don't you let us see? And they said, we're not going to show you anything until we see yours first. So, let's see yours.
And addressing individuals in the same way? Or?
Just
Okay,
however you
okay.
feel more comfortable doing it.
Got it,
Okay? You might want to address them all together, you know, kind of engage them all, good body language like Jack was saying, talk with your hands. And then, you know, see what kind of responses you can get. Okay?
Okay.
Be real. It's got to come from right here. Okay? This isn't a trick. This is you.
So I think a lot of times lawyers will say to people when they're starting this process of voir dire, they'll say things like, you know, this case may not be for you, or this case isn't the right thing. We don't want to put you on the spot. If you have anything private you want to tell us, you can come and ask to speak by the judge. But those are kind of standard things. What I think I'd really like to tell you is that, well, personally, myself, just in the last several months, I went through jury duty, wound up sitting in the box just like you are, and I got a chance to really think through and pay attention to what the experience is for people like you to go through. That is to say, people in your position, and then compared it to how I feel as an attorney when I have to do it. That is to say, when I'm standing addressing you. I mean, I feel like I have a responsibility here, not just to do what sort of the system says I should do, but really, there's a person who, let's not kid ourselves, to some degree or another is really relying on me to help him with something that he can't do for himself.
Let me stop you right there. Paul's going to be your client.
Okay.
Okay. What's his name?
John Smith.
Okay. I mean the real guy.
My client?
In the case you're working on.
His name is Matthew Hendricks.
Okay. Matthew is right here with us. Okay. Now you mentioned a little something about you feel a responsibility to him.
Yes.
Okay. What I want you to do is come over here and sit down and talk to Matthew for about 10, 15 seconds. Sit down. Tell Matthew how you feel about that responsibility. There's nobody else here but you and him right now.
Well, I wish I could tell you different, but I can't. This is a tough case for you. There's an old saying in the legal system, res ipsa loquitur, which things speak for themselves. Guns do not get between the mattresses of beds unless somebody put them there.
Here's what I want you to do. I want you to talk, we talked about the feeling of responsibility you have towards him.
Yeah.
Okay? I want you to just think out loud right now. Look at Matthew, and think out loud. Okay, your soliloquy inside you. When you look at Matthew and you think about the responsibility you have as a person, what do you feel?
I feel that there's a lot riding on this. You're looking at going to prison for quite a while. There's other issues in the case about a probation violation, but let's just put that aside. You
bring it from down here in your heart, not up here in your head.
Well, the reality of it is, this is not going to be easy. And
tell us how you feel.
I feel really worried that you're going to get convicted. I feel really scared that you're going to get convicted, that you have, and that you're going to pay a penalty for this.
He trusts you. He's counting on you.
I know that you're counting on me, and I wish I could tell you that I was Superman and that I could just lift buildings and make things happen, but I'm not.
And that makes me feel
scared. It makes me feel, honestly,
yes,
inadequate. It's that the reality of it is that a criminal defense lawyer walks around with about 10% of me as a criminal defense lawyer. I walk around with about 10% of my psyche constantly feeling like I'm really not good enough.
Yes.
That's right. And no matter what I do, no matter how much I try, no matter how many cases I win, no matter how many, there's always that next one, and there's always going to be the one that I'm going to get my ass handed to me. And ultimately, yes, it is probably, in my mind, unfortunately, it's more about me than it is about you. Honesty?
Right. Okay, now, you're going to talk with these people just like you talked to Matthew. You're going to talk to them from here, not here. Okay? Go.
We've all got a pretty serious responsibility ahead of us here. There are some very difficult issues and difficult things that are going to be discussed over the next several days.
You didn't use that kind of language when you were talking to Matthew, did you?
I'm sorry.
You didn't talk to Matthew that way. Difficult issues, that kind of.
No, that's legalese. Yeah.
Yeah. Tell them how you feel. Tell them how. Stand here and be here now, in front of the jury.
Okay.
What's going on in your gut?
I'm really worried that Matthew could get convicted of this crime, and that I'll look like a schmuck because I didn't win the case, because that's what people really expect of a lawyer. Isn't that what people really expect? People really expect that lawyer, if he wins, he's great. If he loses, he's not. He or she. It doesn't matter how bad the case is against your client. It doesn't matter if you win, you're great. If you lose, you don't.
I'm going to take a moment here to say a more brilliant thing that we have just seen probably will not happen today. And if we can end on that brilliant note, I think, I'll turn it to you guys, but I think that's as brilliant as it gets.
Can I just add something? I have to disagree, and I have to tell you that I think he should be talking about his fear for the client, not looking like a schmuck.
Well, like I said, we didn't have much time to work.
I know, but I'm just saying, I think the approach that I would take is to talk about representing the client.
Mr. Zwirling, you were good 100% right up to that last sentence, correct?
Which is what?
The last sentence was about being a schmuck. Right up until then, you were there, right?
It was all about how he felt. It's not how the client was feeling. Being a young black guy who everybody thinks must be involved with drugs and guns, and having to face a white jury, and counting on you to be able to communicate with
your peers, and that's when you can say the
Sure.
inadequacy.
You're absolutely right. I think if we had more time to work with him, you know, I mean, he never saw this coming, I don't think. One last thing I want to take about 30 seconds here. I want to check in with the jurors. How are you guys feeling about this guy now?
Different.
Different. How so? Say more.
In the first series of questions, I didn't want to divulge one iota more than absolutely necessary.
You weren't going to give him anything, were you?
Not
How about now?
Some.
Why?
So he's a human being I can relate to.
Just like you, right? Okay. So anyway, and Paul needs some, but that's kind of what we do. Good work.
EX, I don't think we'll get a chance to run the PowerPoint. We can get through it in about 2 or 3 minutes, and that's what I want to talk to you about. I spent 5 years as a federal defender from 01 to 06, and how many times those are cases where you're in federal court, do you just walk up to the jury rail and say hi? How many times? I want a quick version of, oh, I need to plug you in. You won't let him do that for me. Send that over there. The quick version of how I try to do it, even now that I'm back in state court. I remember leaving federal court in 06 and trying a case in state court about 30 days later where I got to walk up to the jury rail and look them in the eyeballs and got to walk up to the witness stand and call her a piece of shit. And, you know, in federal court, you're so far away that you can't hardly see the jury. So to try to get there as quickly as possible, the questionnaire, the jury questionnaire. This is a case that was tried about 1.5 years ago, highly publicized murder case. This is some of EX's stuff. It was, the client was rated D-. The dead guy, her husband, was A+. Our objective was to try and get a change of venue from Pryor, Oklahoma to anywhere. Because the dead guy was born and raised there, and we could just see it coming. So and this is Wendy on the right, and this is the snitch on the left, her boyfriend. And so we came up with this questionnaire. I'm going to send this to Keith. Keith, this is a motion for individual sequestration voir dire. I know Aaron and I talked about this briefly. I have mixed feelings about how it works. This is a case that Garvin Isaacs tried about 1.5 years ago, at the same time that I was trying the case that I was involved in. Huge publicity. He actually got a change of venue. I don't know that, and the result was good. This gal was married to the warden, and she takes off with an inmate who was there doing life. It was gone for 10 years. Garvin gets it down to a misdemeanor jury verdict. The news coverage in our case was just overwhelming in that area. So we go into it with, let me skip over here. This is some of the 150 jurors that Judge McBride issued summons to with our questionnaire, which I'll show you here in just a second. Initially, of the 150 that were subpoenaed for the first trial, 46 showed up. And of the 46 that showed up, even the judge could tell by looking at the 10-question jury questionnaire that these people were subject to excusal for cause, couldn't pick a jury. So he resets it, calls the other 46 back, issues some more subpoenas, and this is what we worked off of, this proposed jury questionnaire. EX, I can't get it. And it's a total of nine questions. And it went out with the jury summons. So we had plenty of time to look it over and come up with our reason to try and get a change of venue. I'm going to get out of here on this, but the cell phone We heard all about cell phones today. And in this case, we had it won until the last witness, who talked about securing the cell phone from Wendy, getting a search warrant, and picking up the 40-odd text messages between her and her boyfriend on the day he, and we allege others, were involved in killing her husband. It was like, when talking to the jury afterwards, we were with you all the way until we saw those text messages. And boy, is that a good example of what that can do to you. I really firmly believe in these questionnaires. There's an article that was in the Champion within the last month or two. David mentioned Robert Hirschhorn. It's 30-minute Voir dire. And it's everything that we've talked about, these guys have talked about. And what I've just mentioned to you is the importance of a questionnaire. And get it, read it when you're limited to 30 minutes or no contact with a jury. I mean, to walk back into state court and have an opportunity to just say hi, like Jack does, and tell me about it, tell me what's going on in your mind. I mean, it was just overwhelming. But you can win without talking to the jury in voir dire. You can win. And that questionnaire is so damn important. We use it all the time in federal court. I try to use it in every case I'm involved with. Thank you guys for coming. I wish we'd have had, David Smith alone could probably sit here and talk to you all day about this stuff. The rest of these guys have got more experience than probably in the whole room combined, with all due respect. I'm really getting down, getting dirty. It's been a pleasure to be here. It's an honor to be here with brothers and sisters in NORML. We love you. We love you.
And we are honored. We have a 5 o'clock opening reception. We have an amazing silent auction upstairs. And I'd like to hear the full day or full weekend version of that. That was some magical stuff. Thank you, gentlemen.
Hello. For those of you that like more structured lunches where you have intelligent conversation, I'm inviting you to join us and gather right at the top of this deck. And we're going to do lunch together, and we're really inviting all the experts who have talked to share lunch with us to have intelligent conversation that would inspire. And have lunch. Thank you.
This concludes Thursday coverage of the...
In the category of Don't Let the Dollar Hit You, Cynthia Silva Burbach is no longer Removal Department as of tomorrow. For Colorado people.
I'd like to remind that apparently Cynthia Burbach is not regulated by the Colorado Department as of tomorrow.
Thank you very much.